This conference will now be recorded.
All right. First, I'd like to thank everybody for taking time out of their evening to join us today. I'm Kevin Herzl, so I'm the managing member of Herzl Law, and as we've been dealing with COVID-19, we've had a series of webinars that we put out on a variety of different topics. The issue that we seem to be getting a lot of questions about right now is reopening the common areas, as the restrictions have been eased by the governor. So what we did today is we're going to put on a webinar for you that deals with reopening issues. So we're going to start with Matt Doom and Gloom Heron, who is going to tell you about all the potential risks and the issues that you're going to face in making decisions about whether or not to go ahead and reopen.
Click to join, but it said something about an app.
If everybody could mute microphones so we don't have background noise, that would be helpful.
Let me see.
There we go. So then after Matt gets done, what we're going to do is go ahead and turn it over to Kaylee Long, who's going to give you the positive side, and she's going to tell you what you can do to minimize and reduce risk when you're making, if you make the decision to go ahead and reopen the common areas. And then Joe's going to finish it up. We're going to talk about meetings, how to conduct meetings, what you can do in the way of online meetings as far as moving forward in the future. So, before Matt goes ahead and gets started, I just wanted to lay out, a few ground rules. If everybody could at least turn the cameras off while we're recording this for the presentation, that would be useful. If you can keep your microphones on mute, feel free to ask us questions during the presentation using the chat function. So that's going to be in the upper right-hand corner of your screen. If you click on that and you go ahead and type something in, I'll be moderating and trying to get those questions asked at the appropriate time. We've had some questions that were submitted in advance, and I'll be asking those questions throughout. And then at the end, we can go ahead and open up everybody's microphone and you can turn your cameras on, and we'll field questions that way as well. So we're going to go ahead and get started with Matt. But before we do get started with Matt, just a couple of things that I do want to say is that, a lot of these decisions that boards are facing about reopening, they're difficult decisions, and there's not necessarily a right or wrong answer to it. And so every association, depending on the amenities that they're having, the makeup of their community, the size of their community, what their risk tolerance is, they may make different decisions on these. And really, the purpose of this is to tell you what the pros and cons are, so you at least know what the risks are. You can evaluate them and then minimize them. If your particular community decides to move forward. We've had a few that have just decided not to reopen, and that's a perfectly acceptable decision. And so, really, like I said, the purpose of this is to allow you to appropriately evaluate risk. So, if you have specific questions related to your community, certainly feel free to contact us to get a formal legal opinion on that. But we'll do the best that we can to answer general questions throughout the evening tonight. So I'm going to go ahead and I want everybody to note too that out of Matt and Joe, I was the one that was kind enough to shave for all of you and planning on re-entering society here. But in any event, I'm going to go ahead and turn that over to Matt and let him get started with the PowerPoint.
All right, thank you very much, Kevin. So mine is a little bit of a doom and gloom, but the basis for my portion of it is to, and Kevin alluded to this, but basically allow everybody to make informed decisions. If you know the risks, then you can make the best decision that you can, given all the circumstances. And so the first part of this, first part of the presentation is really going to be looking at the questions of, can we reopen, somewhat, the factors that go into should we reopen. And then once we turn it over to Kaylee, it's going to be more of a question of how do we reopen and what steps do we take. And so the first portion of this is risk, is liability, and is generally going to be somewhat of the liability side of things. So first off, what I wanted to get into was to identify just the general areas themselves. What are the risk categories that we would expect the board to be concerned about? What are the risk categories that would be that you'd really face? One of the, and it listed here, these issues I intend to cover. One area that you won't see on here that is an impact that many associations will feel the impact of is the impact of lowered assessments. We do kind of expect that with the financial and economic impact of COVID-19, that each association's offers to a certain extent may be lessened, and there may be a financial impact as a result of COVID-19. That reduction in assessments is not something that I'm going to be touching on, nor do I really expect anybody else to touch on that. What we're really concerned about here are liability issues that are associated with the process of reopening. First and foremost, and this is the one that was at the top of the list that sort of identified those risk categories, is health and safety. Each association primary concern really should be to take steps to protect the health, safety, and well-being of its members. You should be aware, members should be made aware that the reopening of common facilities does create a risk that employees, members, guests, anybody else may contract COVID-19 from either the facility itself and its surfaces or from others at the facility, which could be members using the facility, employees managing the facility, or other employees in the facility itself. The types of areas that we're going to be talking about, the types of areas that are really at risk are pools. That's going to be a big one. Even under Executive Order 110, there is a distinction, indoor versus outdoor pools. We're also going to take a quick look at fitness centers, tennis courts, basketball courts, and then common rooms and clubhouses. These are each areas where an association is, and we know you all are, struggling to make decisions as to can we reopen, and ultimately, if we choose to do so, how do we reopen that particular facility?
Yeah, and I guess just to piggyback on that a little bit, Matt, I mean, one of the issues that we're dealing with here is it's called the novel coronavirus for a reason. And that's because it's something we've never experienced before. So, right now what the CDC guidelines, say about how the virus is transmitted is that there is a low risk associated, with touching surfaces. The high risk and, sort of what we're I think going to be focusing on, is certainly going to be the in-person contact and maintaining, the 6 feet as far as the water droplets. But the CDC guidance, I mean, it has changed over time since we've started encountering this. So even though they currently indicate that there's a low risk, it's certainly possible that in another month or two, they could say that, you have a higher chance of, contracting it from surfaces if additional research surfaces. So just keep that, in mind right now that based on the present guidance, the major concern is having people too close together as opposed to actually getting it from a surface. But you're going to want to make sure that you have, I guess, measures in place to, still clean those surfaces or try and minimize that risk as well.
So kind of a launching point for what I'm going to talk about is the executive order that came out on Monday. I'm going to use this kind of as a foil. I'm going to use this as kind of test to a certain extent how different associations perceive their ability to reopen. And along these lines, there is a running sample I'm going to try to use that will kind of be picked apart, which is this fictitious Beverly Hills Condominium Association. Now, I'm unaware of anybody from the city of Beverly Hills here in the state of Michigan on the call. If they are on the call, I apologize in advance if you're in any way offended, but this is meant to be some sort of example to work through it. So what we know is that on June 1st, 2020, this past Monday, Governor Whitmer lifted the stay-at-home order, which had been applicable to all Michigan residents. That's a pretty big deal. It's a pretty big thing. We now have this Beverly Hills Condominium Association. It's a resort-like condominium association with numerous amenities. Anything that anyone in a resort-type community would want. You've got a nail salon, indoor cafe, indoor and outdoor pools, 3 different clubhouses, an indoor fitness center, and outdoor tennis courts. They face a bunch of tough decisions as to what to open. Each of these facilities had been closed during the pendency of the stay-at-home order. Now it's been lifted. They have to make a decision. Well, they're pretty aggressive to begin with. Once the stay-at-home order was lifted, the board immediately reopened all facilities, but out of abundance of caution, they did request that members maintain 6 feet social distancing when possible. And to be extra careful, they posted this all throughout the condominium. Now that may sound good, but the overarching question would be, does the simple lifting of the stay-at-home order justify this board's actions? And anybody on the call should pretty easily recognize that the answer is no, it doesn't. There are many different issues that arise. The stay-at-home order itself, Executive Order 110, that order itself is relatively complicated. And as you make decisions, you can't make these decisions on a wholesale basis for everything throughout the condominium. You really need to make a risk determination based upon each particular thing that you intend to reopen. And part of that's going to be dependent upon whether whether Order 110 even permits that to be opened. Can we reopen? So on this issue, what you should be aware of is derived from Executive Order 110, and really any other executive order is going to be the risk of criminal prosecution and fines. As we look at the activities and the decision-making process of this fictitious Beverly Hills Condominium Association, you should pretty easily recognize that the decision to open everything across the board, including the indoor facilities, indoor gym, indoor pool, probably falls within a violation of Executive Order 110. That's pretty significant because if you look at the executive orders, each of the executive orders says that a willful violation of the executive order itself is a misdemeanor. So the second risk category that we have, in addition to the possible transmission of COVID-19 itself, is the risk of criminal prosecution and fines. It would be a misdemeanor, there's a possibility of fines, but that is a risk depending upon what you choose to open. If you open everything at one time, you're ignoring the distinctions that exist within at least Executive Order 110 and others. So you do need to make decisions based upon what the order itself says. Some of the examples I've listed here are current as of January 1st, but as Kevin suggested, things change on a day-to-day, week-to-week basis. So as you make decisions,
real quick, I think you meant June 1st, not January.
Yeah.
Look, the other thing that's important to note about the order is with respect to the pools, the date for reopening the outdoor pools is June 8th. So we still have a few more days before you get to that. But you know, I guess my main concern with respect to the criminal liability aspect, it's not necessarily that police are going to devote resources to going around, going after board members and associations and stuff. But it's more of, from the insurance aspect, which is Matt's going to talk about, potential exclusions to insurance policies when we get into this.
Right, exclusions that could be triggered by violation of applicable law, which could be an ordinance, it could be an executive order, and it also may be a county level ordinance. It may be a county health official, such as the orders that came out a week and a half or so ago about pools in Macomb County, Wayne County, and Oakland County. The takeaway from this, though, from this particular slide, is be aware of the legal requirements for reopening at the federal, state, and local level. You need to know what these are when you make these decisions. A couple things to back up on. There have been, since this was put together, there have been 2 more executive orders that came out since Monday, 111 and 112, and not all of the executive orders that have been issued in 2020 or 2020 relate to COVID-19. Most of them do, almost all of them do, but not quite all of them. In addition, so I've listed the requirements for Executive Order 110. One to point out would be Executive Order 97, mainly because Executive Order 97 lists some of the safeguards that are incorporated into the permitted activities in 110. So if you're going to look at 2, make sure you look at Executive Order 110 and Executive Order 97. All right, so back to our fictitious Beverly Hills Condo Association. So they get a little bit smart. They decide, you know what, maybe we really shouldn't just open up everything. Let's talk to somebody. Let's figure out what we can and cannot do. So they talk to a couple different people. They consult with an attorney regarding what they can open and what's allowed to be open, and decide, well, you know what, since indoor nail salons and indoor fitness centers are closed, we're going to, under Executive Order 110, we're not going to open those yet, and on the advice of counsel, and we're going to keep those closed. However, we have a lot of members that want to use that indoor pool. And so even though our attorney is recommending that we don't open that indoor pool, we're going to do it anyways. On top of consulting with an attorney, they also consult with a professional cleaning company. And they obtain a cleaning plan and schedule for the indoor pool, the outdoor pool, and their tennis courts and clubhouses in order to help with the reopening process. Cleaning company comes back and says, all right, here's your plan, but they advise against opening the indoor pool because they believe it to be unsanitary. So now you've got an attorney that has recommended that the indoor pool not be open, and you have the cleaning company say, if you choose to open it, we can't stand by it, and in our view, it would be unsanitary to have it open. Nonetheless, the association hires lifeguards for the two pools and baristas for the cafe. So the overarching question is, since the board consulted with an attorney and a cleaning company, is the association insulated from liability? And, you know, as everybody on the call should pretty easily recognize, no, they're generally not going to be insulated from liability. There will be benefits to having consulted, which we'll get to in a second. But there are two main areas of liability that are being addressed in this hypothetical. One is the potential liability of the association itself, the company, the corporation. What liability will the association have? And then for any directors that are on the call, there's a second question of what liability are the directors themselves facing from an individual level. So you have, from a liability standpoint, you've got the potential liability of the association, and you've got the potential liability of the directors. So with respect to the association, here's how some of these potential liabilities you'll see them. I'd like to identify some of these potential areas of liability and how they might manifest themselves to you. So let's say for the outdoor pool, you have a lifeguard who's hired. That lifeguard starts work. That lifeguard is later diagnosed with COVID-19. A couple weeks later, one of their family members then is also diagnosed with COVID-19, and the employee, the lifeguard, claims that they contracted COVID-19 from the employee's lifeguard duties. Now, I'm using a lifeguard in this situation, but obviously this employee can be any type of employee. The point of this is that you have an employee that claims to have contracted COVID-19 from their duties. Now, what you would see is that the lifeguard's concerns are in a lifeguard's contraction of COVID-19 would be part of a workman's compensation claim, which would be subject to the workman's compensation insurance policy if you have one. And so in that instance, that would be the avenue that the association would be looking for if there is a claim by that employee. With respect to the family member, there's no specific case law with respect to COVID-19, but in the past, in the context of asbestos cases, the Supreme Court of the state of Michigan has said that they won't allow what's called secondary exposure cases. So based on the case law as it's out there, my expectation would be is that the court, if there was a claim by an individual in the same household as an employee, I would not expect that claim to go forward because of the past experience of the Supreme Court with respect to the asbestos type cases. So those two are in the employee setting. And so let's talk about members. You've got a co-owner, you've got a member who wants to use the facility. You have a member who routinely uses the outdoor pool. Yeah, that individual is later diagnosed with COVID-19 and files an actual lawsuit against the corporation or against the association. So what are the steps? What are we looking at? How are we trying to evaluate the risk? Now we're looking back in time on something that's already occurred, but prior to such event, ideally what the association would have done is they would have looked at their CGL policy, which is the commercial general liability policy, and consulted to determine if they feel like they're protected and if it would be an insured event. Now, for the most part, we have doubts that the policy would actually apply, but it should still be consulted because there's something called a communicable disease exclusion, which I'll get to in a second, which would be a really big issue if you intend to try to claim there's coverage.
Yeah, I guess just to let everybody know what we're seeing on that point, pretty much every policy that we reviewed here in Michigan has a communicable disease exclusion. I've talked to a few attorneys in Ohio where they've talked to their insurance carriers and seem to think that there's coverage, but we haven't encountered any carriers here in Michigan or any of the agents that have indicated that they think there's going to be coverage with respect to any type of physical damage or any type of personal injury that results from this.
And we have later on, I'll show you an example of what the communicable disease exclusion could look like, not necessarily the exact form that you may or may not have, but one that you can at least see what we're talking about. With respect to actual liability, though, setting aside the question of whether or not you'll have insurance to cover it, in general, to succeed on a claim, that member is going to need to identify that the association breached a duty that was owed by the association. This isn't going to cover everything, but some of the areas of concern that the association should have thought about at the time it chose to reopen was, one, did the association open the outdoor pool too early? And you can see that this is connected to, in part, the executive orders, but it's just an overarching question of, can we reopen now or not? Can we reopen? Did the association take sufficient steps to clean? This goes kind of hand in hand with the cleaning company concept that I introduced, but basically this is going to be, did we take steps to implement sufficient safeguards? Has the association complied with all executive orders and CDC guidelines? And are they enforcing the rules and regulations regarding the facility which may have been adopted? These are things that you will need to think about prior to opening, and then as you continue to operate if you choose to open. In essence, what these boil down to are different ways to approach the questions of, look, did the association adequately and reasonably warn members of the risks associated with use? Have they implemented sufficient safeguards? And are they enforcing the guidelines that may have been adopted to try to protect their co-owners? These are the areas that will form theories to be used by plaintiffs if COVID-19 is later contracted by a user of the facility. In the example that I'd given with respect to the Beverly Hills Condo Association, you should see that the opening of the indoor pool would be a problem. I know the example was that somebody contracted from the outdoor pool, but opening the indoor pool is going to be a big problem for this particular association, not just because it violated the executive order, depending upon the timing of it, but it also contradicted the advice of an attorney and the advice that they had been given by the cleaning company. That's going to pose pretty significant issues. Between those pretty significant issues, from the director's standpoint, individual directors on the board are going to be making these decisions as to what to do, and that's what they're tasked with. Directors make the decisions on behalf of the rest of the co-owners and on behalf of the association. There's a standard of care that directors must abide by. And as volunteers, there's some benefits that the Nonprofit Corporation Act provides to these directors. One of these benefits is that a director is entitled to rely upon advice given to the director who is if the professional being relied upon is competent in the matter presented. That's provided by MCL 450.2541. The significance of this is that if the director is following the advice given to that director with respect to whether it's reopening, whether with issues that fall within the expertise of that individual, then in a claim by a third party against both the association and the individual director, that individual director may be able and should be able to defend on the basis that they followed the advice given to them by a professional third party. And in the example that I had given with respect to the Beverly Hills Condo Association, you can see they're not going to be able to avail themselves of these protections because they, at least with respect to liability arising out of the indoor pool against the advice of both its counsel and the cleaning company. So that will be a very significant issue for them. This act provides both the standard of care and it gives you a way to address it. And if you don't satisfy it, it's going to present an issue for you.
And just to chime in there real quick, Matt, do you want to talk about, I guess, the differences between limiting the director and officer liability versus limiting the association liability and what's easier to do?
Sure, I can kind of do that. Kaylee's going to take a little bit on because there's, in the Nonprofit Corporation Act, by amending documents, you can limit the individual director's liability by making specific changes that are permitted by the act. And that's not going to alter the association's liability itself in the event the association makes a mistake. But there are specific protections that can be incorporated into your documents that are permitted by the Nonprofit Corporation Act. And the idea is decision makers, if they act reasonably, if they're doing the best they can, as long as they satisfy the particular standards, there's a less liability threshold for them versus the association. You can bake that into your documents.
Yeah, I mean, I think the key takeaway here is that you have the ability, with the exception of acts that are going to intentionally harm the association, to limit director and officer liability. So you can get rid of gross negligence and negligence. With respect to the association, what we're going to see a little bit later on is you can, if there's certain steps you can take to eliminate regular negligence claims, but not gross negligence or intentional acts.
So with respect to the directors, if you're looking at a potential exposure of liability from the perspective of a director or officer, there's a couple things that you're going to want to do. First, you're going to want to look at your directors and officer D&O insurance policy. What you should know is that if you take the Beverly Hills Condo Association example again, a violation of the law, as Kevin suggested, is that if you have an intentional act or a violation of the law, that's likely going to exclude coverage under the D&O policy. So if you have, as a decision maker, if you have a series of directors who are violating an executive order in order to move forward with the reopening of something, that is going to pose big issues for that association, both from the association's perspective and from the perspective of the individual directors that made that decision. So lastly, with respect to this particular issue, the member, in order to succeed on a D&O on a claim against the individual director, they're going to need to be able to demonstrate that there's a breach of fiduciary duty. Did you follow, as I indicated, did you follow the advice of a competent professional? If you did, you're going to be able to avail yourselves of the benefit of the act. And did you act in violation of the applicable executive order or other law? If you did, then you're probably going to trigger an exclusion under the policy. So at least with respect to COVID-19, those are a couple of things I wanted to make people aware of. With respect to the liability of the association, and this is on insurance issues, ideally, the association would look to the CGL policy. A CGL policy is intended to cover liability for bodily injury to others. As Kevin indicated, we don't really expect this to apply, but you should at least know some of the principles that are here in order to maximize the possibility of being able to present a claim. The first question is going to be, was there an accident? Was there an occurrence? Insurance is intended to address matters that are not preventable. An accident, something that could not be foreseen. So if you are opening in a way that maximizes risk, that is taking risks that are known, then you are going to fall into preventable category of events, and it's less likely that it would be viewed as an accident. The more protections that you take, the more precautions that you take, the more likely it is that you'd be able to claim that it's an accident. The overarching question being, was the harm foreseeable to the insured? That's going to maximize your ability to have it categorized as an accident. The other question is going to be whether there's exclusions. As Kevin indicated, the communicable disease exclusion is going to be one of the most significant. There are other potential exclusions that an insurer may attempt to rely on, but the communicable disease exclusion is probably going to be the most significant and the one that's most relevant and applicable to you. At least in my view, if you're trying to put yourselves in a position where it's possible to make a claim, you're going to want to maximize the possibility of an event being viewed as an accident, which means taking as many of the precautions, many of the how to make things safe that Kaylee is going to go over. This is an example of the communicable disease exclusion, communicable being more difficult to say as time goes on, but this is kind of what it would look like. And one thing I'd like to point out with respect to the exclusions is that with respect to coverage, anybody that's litigated or anybody that's been involved in an insurance claim or an insurance lawsuit knows that in the state of Michigan, an insurer's duty to defend is bigger than the insurer's duty to indemnify. And what that means is that there may be instances where there is no coverage for the underlying liability, but the insurer themselves may be obligated to defend until that determination is made. And so just because you believe that that coverage may not exist, it doesn't hurt to ask the question, to ask your attorney, to ask counsel, and possibly to put the insurer on notice of the claim in order to maximize the possibility of obtaining coverage for purposes of defense.
Yeah, I guess just to chime in there, I think really if I had to pin down what's the biggest financial risk to most associations, it's going to be the fact that the insurance carrier doesn't step in to provide the defense and the legal fees. In my opinion, it's going to be very difficult to demonstrate causation, that you were actually contracted, coronavirus from going to the swimming pool or somewhere else, as opposed to getting it at, the grocery store, Starbucks, that kind of thing. Unless there is, some sort of mass event where you can show that you had 10 or 20 people that were all together and, they all came away with coronavirus. I think the causation aspect of this is going to be a difficult hurdle, for a plaintiff to overcome. The issue is that, if somebody is seriously injured, or dies, that that's going to be a high dollar damage claim that you're going to be dealing with, and that you're going to be paying those unbudgeted defense costs out of your budget. If somebody comes after you for one of those lawsuits, and the co-owners are going to have to pay for that. So while I think causation is going to be difficult to establish, it's really more the cost of defense, which I kind of see as, one of the major risks for associations in these types of cases.
So lastly, in deciding whether to reopen or not, some of the factors that I consider are listed here, and I divide these up, at least in my mind, into two different categories. Can we reopen? It's the first two. Will the use comply with the law? And can we adopt rules and regulations to allow us to meet compliance requirements established by the law? And can we enforce those? That's going to be the can we. And then you have the should we questions, which is given the burden on the association in reopening against the benefit to the members in reopening, really should we do so? And then lastly, is the association insured in case of liability? I kind of covered the insurance issue already, but these are the factors that go into can we reopen or should we reopen? With that, at least I'll take some questions, some that are relevant. Otherwise, what I would do is turn it over to Kaylee.
Yeah, we had a couple, I guess, questions that came in, that I'll go ahead and pose to you here. One of the big things, I think we should emphasize, though, is that if you do make the decision not to reopen and you are sued for making the decision not to reopen, pretty much most of the insurance carriers are going to say that's a covered claim under your insurance policy, and that you would have not only, a defense, but possible indemnification, for that type of issue. So, certainly, that's something to be aware of when you're making this decision, weighing, if somebody gets hurt and having a not covered claim for reopening with a high dollar damage type of claim, or, a low dollar damage type of claim, that if the association gets sued, simply, for not reopening the pool, I mean, the judge would probably order the pool be reopened. And then, you have the judge making that decision, as opposed to the owner. So a couple questions that we got, for Matt related to that issue is, how should the board address co-owner requests for a refund of their monthly, dues or their assessments, if they're not allowed to access some of these facilities, and is that a potential liability claim that the association's exposed to?
I do not see that as a liability claim. There's two reasons. One, bylaws already say that a dispute regarding use of common elements doesn't necessarily result in you can't ask for your assessments back. Substantively, though, and in addition to that, assessment is going to be based upon a budget that's done at the beginning of the year. It's going to be based upon, in some instances, there'll be a deficit. In some instances, there's going to be an overage. Just because funds may not have been used, that may have been allocated to use of a common element or maintaining a common element, or somebody wasn't able to use that particular common element, to me doesn't mean that there should be a refund. I just don't see a basis to allow somebody to get a refund, or that I don't see a basis to require the board to refund the members, at least from my standpoint.
Yeah, and I mean, that's consistent with the Condominium Act and case law that we have, is that non-use, of a facility doesn't entitle you to any type of a refund. The other question that we received is, what happens if the board decides not to reopen a facility? What kind of summary or information should they provide to the co-owners?
Well, if you choose not to open it, so I guess there's two things. One is, in my view, they can make that decision not to reopen. Especially during the state of emergency. In my view, it would be reasonable not to do that. Beyond that, the board is going to be empowered to administer and make decisions with respect to the use of the common elements. So kind of like you suggested, from their standpoint, they can make that decision, and the most that can likely be done is they'd be ordered to open it from the decision of the judge. What should they tell their co-owners? I do think they should at least let people know what's happening, let people know the reason for it. The idea being is that the ultimate question is going to be, is the board's conduct reasonable under the circumstances? And notifying people of the reason for the closure and letting them know what's going on is going to be able to support that question of reasonableness. So if the question is, should we tell people? In my view, the answer is yes, and you should connect it to the reason for the closure, which is COVID-19.
And just to kind of follow up on that point, part of the calculus about whether to reopen or to not reopen, is certainly financial. So, one of the questions I've seen, from a lot of board members is this something we should let the community vote on? Ultimately, whether you're opening or reopening, that's a board decision. It has to be made by the board, but certainly if you're going to reopen, that there's going to be some sort of increased financial cost that was unanticipated in order to safely operate the recreational facilities. And so, certainly that's part of the business judgment decision that the board makes. So I've seen some associations, they've put out a survey or they've asked for input. If we reopened, would you be willing to pay an additional assessment, to cover all these costs to, safely operate? So, that's certainly, another factor as well. We did get one question here right before we move on to Kaylee. It says, if we have a basketball and tennis court with a combination lock on them, but the homeowners in good standing have the combination of the lock, how would we cover the association in the event that someone contracts the virus? So I think that sort of goes back, to some of Matt's points, is that you need to first make the decision to open or reopen. If you make the decision to not reopen, I would certainly just, change, the lock and not have the combination. For the issue with respect to the tennis courts, I mean, that's certainly an outdoor recreational facility that could be used, at this point. The USDA, they've published guidelines as far as how to use tennis courts and maintaining social distancing. But for something like that, you would probably want to adopt a rule that you're not allowing people to play doubles and you just have one person on each side, and maybe that they have a marked ball, and so you're not necessarily sharing tennis balls. Basketball is going to be a little bit more difficult because you could certainly allow the court, to be open to use maybe for one or two people, for that type of thing. But you certainly couldn't have a 5-on-5 game of pickup basketball based on the current order, because you wouldn't be maintaining 6 feet of social distancing doing that. So, for the basketball court, if you want to keep that, closed, I think that would be fine, or just open it up to very limited use. You're going to need some very specific rules on that. With respect to the tennis court, that's something that I think you could probably open up safely now. So I'm going to go ahead and turn that over to Kaylee now and let her get started on all the different things that you can do to minimize the bad stuff that Matt just told you about.
Okay, so as Kevin said, Matt has walked you through all the doom and gloom. And so now we're going to address some best practices for associations who do decide to reopen some or all of their non-essential common areas. So things like your swimming pools, clubhouses, etc. And so just to reiterate where we're at in this scheme of things, Matt talked about whether an association can actually reopen their common areas in compliance with federal, state, and local orders, and also whether you should reopen those common areas in light of the risk and potential liabilities that you may face if you decide to open those common areas. And so now my portion is really how to address those risk and potential liabilities in an attempt to reduce them. So we should be clear here that this is not going to eliminate your risk or liability, but they are designed to help at least reduce them. So we have here 7 different recommendations. So if you're a director, an officer, these are 7 different recommendations. If you've decided that you're going to reopen your common areas, to take a look at and discuss with each other as to whether you're going to adopt these. And if you're a property manager, whether you want to take these back to your boards who are deciding to reopen their common areas. So there's 3 buckets of these recommendations. The first bucket is an amendment to the governing documents to reduce officer and director liability and also association liability. The second bucket are recommendations that are designed really to regulate residents' conduct when they're using those common areas. And then the last bucket is informing your residents of the risk if they decide to use the reopened common areas. So in the first bucket of amending your governing documents, Matt touched on this earlier about, and Kevin discussed this earlier as well, about trying to limit your director and officers' liability. So this would be a situation where you've reopened the common areas, you have a member who contracts COVID-19, and they sue not just the association, but the individual directors and officers as well. And so the Michigan Nonprofit Corporation Act allows an association to include either in their articles of incorporation or their corporate bylaws an exemption from liability for negligent and grossly negligent conduct. However, these exemptions have to be in your actual documents. So you're going to want to take a look at the association's articles of incorporation, their corporate bylaws, or if you're a condominium, your condominium bylaws, and see if you have a liability exemption within your documents. Some people may not have any liability exemption language. Some people may just have an exemption for negligent conduct, but not grossly negligent conduct. And so, as Matt reiterated, this is really meant to address that potential gap of lack of insurance coverage in the event that your volunteer directors and officers get sued, and at a later date, the association might have to pick up the legal costs that they incurred to the lawsuit.
And just, I guess, a couple quick points on this. A lot of people get deterred, from doing document amendments just because of how much work it is. Generally speaking, the articles of incorporation, unless they specifically have an amendment provision in them, you only need a majority of a quorum in order to be able to do that amendment, as opposed to condominium bylaws where you're talking about getting 2/3 of all co-owners to do that. And even if you do have insurance, one of the things to be aware of is if you do get sued, your insurance rates are determined by what your loss run is, and so they will go back and take a look at any claims that have been made. And so if you have these types of provisions, it'll make it a lot easier to get rid of lawsuits against directors and officers. And so even if you do have to put in a claim on your insurance, you'll probably be, saving money and minimizing, the rates that your insurance goes up.
Okay, so again, the action step for that recommendation is either as directors or officers or as property managers advising your boards, take a look at the governing documents and see what sort of exemptions of liability you have for your directors and officers, and consider whether an amendment to those would be appropriate to further limit the liability for those directors and officers. The second set of document amendments that we have are, screens go. Oh, there we go. Okay, so is amending the either master deed of your condominium or the declaration if you're a homeowners association. So again, this was mentioned earlier by Matt of, including potential waivers within your documents themselves. So we're all familiar with the individual waivers, which I'm going to address towards the end of my presentation. But this basically bakes in a waiver into your actual master deed or declaration. So instead of having to go out, get signatures for all of your residents, this is included within your governing documents. And again, this is really meant to address associations who have really gone through and taken, reasonable steps of they've contracted with a professional cleaning company. They've gotten that increased cleaning schedule and plan. Maybe that contracting company is also performing the cleaning services themselves. But despite all your best efforts, one of your members still contracts COVID-19 and says it's from one of the common elements. And so what we're recommending is including that waiver provision within your governing documents, indicating that the association is going to do the cleaning that it deems appropriate, but co-owners or residents, you still may be exposed to COVID-19 despite all these measures that we're taking. And so you are acknowledging that this risk is present. If you use the common areas, you're assuming that risk, and you're going to waive any negligence claim you have against the association. As Kevin mentioned earlier, though, in Michigan, you can only waive negligence or negligent conduct, so this would not apply to grossly negligent conduct like it possibly could for directors and officers, depending on what your governing documents say. And then also, just briefly, so if you, most associations don't have this language in there regarding waiver for COVID-19 or viruses or bacteria. So if this is something that you're interested in, if you're a condominium, it will require a co-owner vote. If you're a homeowners association, you want to take a look at the amendment provision within your specific declaration. But Joe at the end is going to kind of talk about some possible options for meetings on if you decide to do a document amendment, how you can run that meeting and get your residents to be able to vote on one of those document amendments.
And I guess real quick, I mean, one of the, reasons we developed this, there was a case that came out recently from Georgia, and it dealt with third-party criminal acts and whether, the association had a duty to maintain security cameras to prevent people from being subject to, criminal acts by third parties. And they actually had language in their documents that, it indicated, that while we have this out there, this doesn't ensure your safety and that kind of thing. And so the court relied on that, in finding that the association didn't have liability. So the provision that we've sort of dealt with, it deals with third-party criminal acts. It certainly deals with viruses and bacteria, COVID-19. It's certainly going to deal with, certain natural disasters that may not be covered by insurance as well. And so we've tried to, develop, something there that's going to bridge the gap in the event that you don't have insurance coverage. One of the questions, real quick, before we move on, that was asked about, if you do these types of amendments while the COVID crisis is already underway, is that going to be considered valid? So, that was asked in the context of the articles, and, certainly, you would need to have that provision, voted on and approved. And once that's voted on and approved, that's anybody that's going to sue you, after that, would be subject to those liability limitations. The same is going to hold true for, getting that waiver in your documents. Putting the waiver in, in the master deed right now is not going to necessarily, preclude, pre-existing, claims that existed before the date of that amendment. But certainly, if you can get that in quickly, before you make the decision to reopen and get a co-owner vote, real quick before we really start getting into summer here, or get that in, in the case that there's, a second wave of coronavirus that comes in the fall, that's something that certainly would be beneficial, especially because, this whole thing was something that wasn't contemplated at the time.
Okay, so now we're going to move into the second bucket of recommendations, which is regulating your residents' conduct and using the reopened areas. And so what's really important here is that while some of these access and use policies that we recommend here can apply across the board to many of your common areas, you really are going to have to sit down and think through some access and use policies for each of your common areas, just because each of them are unique and they're going to present different problems for or potential problems for you that you will want to think through. So some ideas or some policies that we can think that you should consider and implementing or should be mulling over when you're creating these access and use policies are sort of the following. So for example, equipment. Kevin mentioned earlier, as of now, it seems like COVID-19 doesn't transmit as easily on surfaces, but you're going to want to think about what sort of equipment and materials that you would typically provide to your residents and whether you want to keep on providing those materials and equipment to those residents. So for example, swimming pools, if you have pool chairs out, you're going to want to think about, do we want to keep providing those pool chairs? How easily can we clean them? How frequently can we clean them? And you may decide that your association maybe doesn't have the operational capacity to make sure that they get cleaned every day or as frequently as they need to be. So maybe you decide we're going to store the pool chairs away and we're going to ask residents to bring chairs and take them with them to kind of decrease our cleaning burden. You can also use that equipment and materials though to encourage your co-owners to reduce their capacity. So let's say, for example, you have 15 pool chairs, but you only want 8 residents at a time in the area. You might want to consider storing away 7 of those chairs, just to really try to limit the capacity of who's coming into the common areas. You can also consider having residents screen their temperatures with an infrared wall thermometer. We have one here at our office. It's installed on the thermometer or is installed on the wall. You don't have to touch it. You just stand in front of it. It takes your temperature and just verifies that you're not running a fever. So you'll want your residents to screen in general, also to make sure that they're not sick, make sure that they're not experiencing any symptoms. But that's at least a way that you can have the residents before they're entering the common area, just to make sure that they don't have a temperature. You'll also want to comply with any capacity requirements or honestly any other operational requirements that are coming down from the state and local counties. So the Executive Order 110 does allow our outdoor swimming pools to open, but right now they're at 50% bather capacity. So you'll want to make sure that your capacity is limited to whatever requirements are coming from the state and county. And maybe you decide 50% capacity is still too much for us. We can't maintain social distancing even with that amount of people. So maybe it's best for your association to limit it to 25%. And we should also note too, for swimming pools, while you can reopen on June 8th, you have to have a permit. So make sure that in addition to any capacity or operational requirements, that you get that permit before you decide to reopen.
Just real quick, we've gotten a couple questions on this topic, playgrounds. So I guess, do you have any advice on, I guess, whether playgrounds can legally reopen and issues associated with that right now?
So playgrounds can reopen. I know Oakland County, certain counties that had previously closed them have reopened them. Playgrounds are tricky, and associations should really think about the feasibility of reopening them. So it will be difficult to maintain social distancing. So if you decide to reopen, you may want to put requirements on how many people, both children and their parents or adults, can be in the playground area at any given time. You really want to encourage them to have hand washing or hand sanitizing stations there, so that way they can be frequently washing and sanitizing their hands. On the part of the association, you're going to want to talk about whether you need to work with a cleaning company to do a cleaning of it on a daily basis. And to, you just have to think, do children understand maintaining social distancing? Children, like on a playground set, can they keep in their minds that they need to stay 6 feet away from other people that are part of their household. So those are all things that, just take into consideration if you decide to reopen that playground.
Yeah, I mean, I would, just to chime in a little bit there, pools are difficult, but you can certainly limit whether people come together or not. You can put lanes in the pool and just limit it to lap swim, so you can kind of avoid, the horseplay. But, certainly on a playground, it's just going to be much more difficult, to monitor that and, ensure that people are maintaining, the 6 feet of social distance. So, I mean, it's going to be a little bit more difficult for that if you decide to reopen it, and then how are you going to monitor it? And the same thing, for basketball, you can certainly create rules to limit, capacity. But, like playing a game of pickup basketball or, getting, 10 kids together on the playground, I think is going to be, really difficult, to safely operate. And so you're going to have a little bit more exposure there than as opposed to somebody playing tennis or pickleball or volleyball or something like that.
So some other considerations, some we've kind of already talked through various parts of this webinar so far, but you may want to decide to either limit or prohibit guests access to the non-essential common areas. So not necessarily restricting them from entering the community, but maybe your residents can't invite guests to the swimming pool this summer. And also, too, Kevin mentioned earlier the potential financial impact that you may incur due to all these increased cleaning costs. And so one way to try to potentially mitigate that is to consider the operation hours of any common areas. So maybe typically it's open, your swimming pool is open 7 days a week for 10 hours every day. Maybe in order to do the cleaning that's necessary and in a cost-effective way that the association can handle, maybe it needs to come down to 5 days a week for 8 hours. So those are some general access and use policies that we recommend that you consider requiring your residents to comply with and implementing and opening and operating those common areas. So the next thing that we're going to talk about is, I can get my screen to go. There we go. So, and one last final thing on the general access and use policies, you want to make sure that whatever access and use policies you adopt, that you actually have the capability of enforcing them. So associations really need to sit down and think about what hands and availability do they have to enforce these access and use policies, because these effectively are rules and regulations. So you're going to want to think about, do you need a security guard? Do you have a vendor that you already work with who might be able to supply employees to come and help enforce rules and regulations? Can you get an on-site property manager? All those that not only adopting access and use policies, but you can actually enforce them at the same time.
Yeah, and I guess real quick on that, certainly you don't want to have volunteers from the association attempting to enforce this for liability reasons. Originally when it came out, people were saying we should have volunteers try and do this to clean. I mean, they're not qualified to do that. I mean, it's really, the responsibility is going to fall on either the board, the property manager, or the best solution, if you can afford it, is to hire a third-party vendor to monitor this. Certainly for liability purposes, if you have rules, you need to make sure that you have the ability to enforce them, because if you create rules and don't enforce them, and really what they're going to need to know is that you knew that the rules were being violated, but you did nothing, that is certainly, going to be an issue if you were sued. With respect to what you can actually take, I mean, certainly if you have somebody out there monitoring that, I mean, the easiest first step is just, to tell them to stop, violating whatever the safety rules are or dealing with that particular conduct. If that doesn't work and it becomes a repeat issue, certainly you would have the ability through fines in most associations to go ahead and enforce that. In an extreme case, if you need to take somebody to court to sue them, to get an injunction against them, that would also be a potential remedy as well.
Okay, so and actually this is one last point on the access and use policies is to make sure that they comply with the Fair Housing Act. So if the board decides to create and draft their own access and use policies, just recommend that you have an attorney take a look at them. Fair Housing Act does prohibit discrimination based on familial status, and some associations fall into a trap by creating rules that specifically limit children's access and use of the common areas. And federal courts have looked at some of these rules and have determined that they are familial discrimination that violates the Fair Housing Act. So that's just something that you should be aware of. And if you decide to draft those on your own, just have an attorney look through them and let you know and advise you on if there need to be any changes to avoid the unexpected liability of a lawsuit because of the Fair Housing Act. So in this continuation of regulating residents' conduct, so now this is specific actions for the board to take regarding the reopening and operation of these common areas. So first we're going to look at indoor common areas. Particularly one thing that you're going to want to focus on is the air quality. Because it's an indoor space and the space is enclosed, you're going to want to make sure that you have adequate ventilation and airflow within that space. So that may be following up with your HVAC specialist to have them come in and make sure that that ventilation and airflow is appropriate to make sure that the likelihood of transmitting COVID-19 in that indoor air is minimized. You also too, as with everything, you're going to want increased cleaning. So you need to work with someone to figure out what's the cleaning plan and schedule for the space going to be. We've already kind of talked about with swimming pools, but same thing with an indoor common area like a clubhouse. You're going to want to think about what furniture or other materials do we have in here, and do we need to move them so residents know how to stay 6 feet apart away from each other. It's one thing for residents to know they have to do it, but if you can set up visual markers for them and show them this is where you can be, that's going to be 6 feet away from other people, that would be very beneficial for those residents. And along those lines, having floor and line markings. So if you have a common area that has a tendency to create lines, as you've seen in the grocery stores, put down some tape or some other signal to show them this is where you can stand at 6 feet away from everyone else. You should also have hand sanitizer stations at entry and exit or hand washing stations. And then to the point Angela asked earlier about tennis courts and basketball courts, you could consider maybe keyless entry instead of a combination lock where your residents are having to touch the combination lock to get in. If you decide to reopen those facilities, if keyless entry is an option, that might be something to look at just to minimize touching by multiple residents on the same surface. So gyms and fitness centers are not open yet. So at this point, we're not recommending that you reopen those, but just some specific considerations for those when the time comes when you may be able to reopen those. Again, same thing we've discussed before. It may be beneficial if you can move your fitness equipment to move it so everyone's spaced out, or if you can't move your equipment, but you have 5 treadmills set up, maybe closing or turning off every other one. You might want to require your residents to bring their own water to discourage the use of the water fountain. And most fitness centers already require this, but providing something so the residents can wipe down the equipment after each use and putting that requirement in the access and use policies. So now outdoor common areas. So it's pretty similar to the indoor common areas. Again, you're going to want to make sure you have an increased cleaning plan and schedule and that you follow through with it. Again, furniture and other items. So there's common contact points like a common grill, grilling tools, or common outdoor games that multiple people might be touching. You might want to remove those items or prohibit people from using them at this time, or if you're going to allow multiple people to use those, to provide some sort of disinfectant and cleaning solutions right near, so that way they can be cleaned after each use. And same thing again, floor or ground and line markings. So this could be, for example, your swimming pool, if you decide we're going to take away all the chairs, residents, you have to bring your own chairs. It might be beneficial for you to set up specific squares on your swimming pool deck to show co-owners, okay, this is where you can put your chairs and still be 6 feet apart from each other. And so swimming pools, you really need to make sure that your water is properly maintained. We've talked about transmission of water. At this point in time, there's no evidence that it can occur, but that's when the water has been properly maintained. So you're really going to want to make sure you stay on top of that. You're going to want to make sure that you keep up with the cleaning. So while through the water, it may not be transmissible, but you'll want to think about the handrails that people are touching to get in and get out of the pool, things of that sort. And you'll want to make sure to do not close your restrooms. You may want to consider closing your locker rooms, but you should leave your restrooms open for the residents to use while they're using the swimming pool. And we've already talked about tennis courts and basketball courts, really just trying to make sure that people who are not part of the same household aren't coming into contact with each other. And so for these, we just recommend the board really should consider any safety protocols that you decide to adopt, even if it's just, we're going to hire this specific cleaning company and they're going to do this work, or we're going to be putting hand sanitizer stations in these locations, we're installing key entry here or keyless entry here, to document all these informal resolutions, just to provide a paper trail to show, in the event that it's ever needed, all the steps that the board took to try to minimize the transmission of COVID-19 in the common areas. So now we're at the last bucket of informing your co-owner or your residents about the potential risk of using the common areas. So you'll want to make sure that you have plenty of signs in any common areas that you open. And so any access and use policies that the association has adopted, you not only want to disseminate that to your residents, but you should post those in the common areas. So they're there for residents to access. A warning to co-owners that COVID-19 could be present and they'll be using the area at their own risk. And the CDC has plenty of safety and guideline posters on their website that you can look at, advising people not to use something if they're sick, the symptoms that they should be looking for, and wearing masks where it's appropriate, and how to properly wash their hands or sanitize their hands. And then last but not least are the individual waivers. So the individual waivers, this is something that we don't recommend an association do standing alone. So this is not something that we recommend the association say, we're just going to do individual waivers and then we're reopening everything. This is really something that we're recommending that you do in conjunction with the other 6 recommendations that we just talked about. At this time, it's just unclear whether a court would uphold a waiver, even if your resident signed it and brought a lawsuit. It's just unclear whether a court would actually uphold it. In Michigan, you can only waive negligence. So again, you still have the risk of grossly negligent, intentional conduct, unless you have staff on site who can control who's coming in and out of the common areas. It may be difficult to verify that a resident has already signed that waiver before they go into the swimming pool or before they go into the clubhouse. And 2, minors cannot sign waivers. So if you have children in your association or in your community, those children aren't going to be able to sign a waiver, and so you're going to be limited in who you can actually have signed waivers and potentially have it enforceable against. So, any questions?
So I guess just to sort of differentiate between the waiver and a master deed and a standalone waiver, the concern there is whether or not there's going to be consideration. So you can certainly have a waiver as long as there's a contract. In order to have a contract, you need to have some form of consideration. So in the context, the master deed, your declaration, the courts have already said those documents are contractual in nature and they contain sets of mutual promises and rules that everybody has agreed to live by. In contrast with the standalone waiver, what the concern is going to be is that if somebody has an argument, well, I already have the legal right to use the common element, what's the consideration for that transaction? So, as Kaylee mentioned, it certainly, could be used to buttress, some of these other things and provide you another legal argument in court. But, part of what we're concerned about is that these standalone waivers may give people a false sense of security. The other thing that you're going to want to be on the lookout for that we haven't seen that's come out today so far is the order, Executive Order 110 indicated that, the Department of Health, they're supposed to be putting out some sort of regulations that relates to pools, outdoor recreational facilities, and it contemplates that. Those are not out yet. We've sent them an email to see if they're going to have anything that's coming out. We did not get a response to that. Certainly, if they come out with some sort of guidance, that's absolutely what you should follow. Until then, really, what we're telling the associations is you need to check with the county, their local Department of Health, and any kind of public rules that they have for swimming pools, recreational facilities. Your best practice is to mirror those privately as well. So before we move on to Joe here, we did have a few questions just with respect to some different amenities that you hadn't touched on, Kaylee. If you want to chime in with respect, is there anything special or different about beaches? And do you have any tips on that? About a shuffleboard court? And then we had a question about whether it will be safe to open up the clubhouse before Labor Day, and what kind of precautions should we take with respect to reopening clubhouses?
So for beaches, the recommendations are going to be pretty similar to everything else. You're going to want to look at any local or public guidelines for any public beaches. So any regulations or protocols that they have in place. So first take a look at those and see what sort of regulations that they have. If there's nothing for you to look at or to follow, you want to think about capacity. So maybe you decide to limit the amount of people who can access the beach if that's something possible and something that can be monitored and enforced. I believe somewhere in France or Italy, they marked off specific areas on the beach for each people to use. So tape is not necessarily going to be a good way to do that, but stakes and strings to show people, hey, this is your spot, and this is how you maintain 6 feet distance between each other. So those are some recommendations on using beaches. A shuffleboard or anything that requires sharing of equipment, you're going to want to think about 2 possible options. One is, do you want to store away that equipment and make your residents or require your residents, if they want to use it, they need to bring their own equipment. That way you're limiting the sharing of items. If it's not something that you want to take away and store away or require your residents to bring, or maybe it's impracticable for them to bring that equipment, again, having some sort of disinfectant or cleaning solution available so that way they can wipe it down after they're done using, and making sure that when they're in the process of using it, if they're with residents who aren't part of the same household, that those people are not sharing it with each other, that they have their own designated equipment. And then the last one was opening the clubhouse. So you can open the clubhouse before Labor Day, although indoor gatherings are limited right now to 10 people. So you're going to want to make sure that you're able to comply with those limitations. And again, you're going to want to take a look at reopening the indoor common areas. So you're going to want to make sure that you have adequate airflow and ventilation. You need to move any furniture or mark off areas so people can meet the 6 feet social distancing requirement. You should consider that. And also too, if you provide any games or activities in that area, you may want to think about storing those games and activities away that lots of people may be touching, and having residents bring with them their own games and activities and then taking them back with them when they're done using the clubhouse.
All right, we had one last question here, and Matt, I guess I'll go ahead and throw this back to you. It was really more of your topic about the duty to warn before we move on to Joe. And that involved, if we have a situation where we've closed down a recreational facility such as a basketball court, and we have somebody that lives outside of the community trespass, and break into the basketball court even though it's locked up, do we still owe a duty to warn them, of these own risks? And do we owe a duty to a trespasser that would be different than, somebody who was invited, as an owner who was invited to the premises as a guest?
The standard is different. There is the, for youth, there is the, I can't remember the exact term, but there's the attraction concept that is out there. But generally, I would not expect the duty to be the same to the trespasser. I know the term that was used was, would we be covered? Really, I would say the question is, are we going to be liable to this individual, and do we owe the duty? I would not, they're not an invitee, they're not a guest. The duty owed to the trespasser is going to be less. I would not expect there to be liability to that trespasser, at least from my standpoint.
Yeah, just to recap before we move on to Joe, that you really don't owe any duties, unless you're aware that they're a trespasser. And for example, if you knew that there was COVID-19 or something there, you owe the lowest level of care to a trespasser as opposed to a licensee guest or a co-owner that would come on your property. So, certainly, trespassers is not, I guess, an area where I would think that you would have, I guess, a lot of potential exposure to liability. You're really going to be concerned about, the co-owners and their guests, and, you can certainly, limit, I guess, who comes into these as far as the number of guests and that kind of thing. And so I think really what we're looking at here is really keeping, the co-owners safe. So I'm going to go ahead and turn it over to Joe, and we're going to touch on the concept of meetings.
All right, everyone. So there's 2 sets of meetings that really we're going to be addressing. The first is just board meetings, getting the directors together to make decisions. How do you do that in a COVID world? And then also talking about how to set up member meetings, annual meetings. And this is generally the time of the year when we have a significant number of annual meetings scheduled or ready to go. And how do you address meeting in person in this type of environment? So just to recap, and we've already discussed it, but right now under the Executive Order 2020-110, which was just issued on Monday, outdoor gatherings are limited to 100 people, and you have to stay 6 feet apart. And indoor gatherings are also limited to just 10 people. And so indoor gatherings, unless you have a very small association, let's say your condominium association's 8 units, you might be able to get away with an indoor gathering. But realistically speaking, the stereotypical every year, everybody gets together, sees their neighbors, votes on different matters, elects new directors, things of that nature. The way that things used to be with in-person meetings, at least temporarily, it's going to be more difficult to do those given the circumstances. So what are your options as a board? Can your board participate and make decisions If they can't meet in person now, they can up to 10 people. That's good. But are there other options? And so the answer is yes. Under the Nonprofit Corporation Act for the state of Michigan, and it's specifically 450.2521, unless your documents restrict your ability to prohibit a director from participating in a board meeting by electronic means, so that would be video or telephone, they're able to participate. There are some caveats to that. The caveat is they have to be able to actually participate. So like right now in this meeting where I've got, I'm speaking and everybody else is essentially on mute, if you don't give the director the ability to participate in the meeting, then no, it wouldn't count. So definitely want to give them that ability to participate. And the benefit is that it specifically says in the statute that the participating in the meeting by phone or by video would constitute actual attendance in person, even though the person's not physically there.
So we got a question that wanted to know if communicating, if the board wanted to communicate via text message, whether that would be an acceptable way to make decisions.
So we're going to get to that in one slide, I think, by text or email. It's actually this slide right here, decisions by email. But let me go back to this slide, finish it up, and we'll get right into that. It's a good question, though. So what are the possible ways right now, given the circumstances, how can you communicate as a board, and what's the best solution for you? And so there's multiple options here. We're using Zoom right now, or GoToMeeting, things of that nature. You've got Skype, you've got FaceTime, Google Hangouts, Microsoft Teams, House Party. Now there are limitations on all of these, and so what makes sense for your board may not make sense for your association if you try to use the same program for both. I'll give you an example. For example, for Zoom, which is very popular right now, the basic time limit is 40 minutes. So if you're going to have a board meeting, you may be able to accomplish everything you need within the 40 minutes. And that allows up to 100 people to participate, except for the fact that if you have an annual meeting and you've got a very large association, that 40 minutes is likely not going to cut it. So you're going to have to pay for that first basic level of service that it allows, which I'm president of my own association in Novi. We paid the $15 per month to allow us to have that unlimited time for up to 100 people for Zoom. And I think it was something to the effect of 15 or 20 bucks a month. And so just for the foreseeable future, we're going to have that option available not only for board meetings, but also for our upcoming annual meeting. The benefit with Zoom also is that if you get there's a premium package where you can get up to 500 people. Skype, the initial package is 50 people, you can get up to 250. FaceTime, it's capped at 32. Freeconferencecall.com, it's 1,000 people. Google Hangouts, it's 150, but only 25 people can be visual on the screen. So the video is limited. Microsoft Teams, it's up to 250, and House Party, it's capped at 8. So when looking at a board meeting, you might look at all of these as potential options. Even House Party, which is kind of ridiculous that this app is even a possibility, but if everybody has the app and they want to utilize it and communicate, you can communicate for a board meeting through these means. All right, so decisions by email. So again, same language as earlier, unless it's restricted in your governing documents, any action required to be taken under authorization of voting in person, it may be taken through an email if, and here's the key language, if it's unanimous. So you have to have unanimous consent to allow this to happen before you can make decisions through email or some other electronic means. So the question earlier was about text messages. Could that be sufficient? Well, I don't know about you and your association, but in my association, we routinely get, hey, there's 5 of us, 3 of us agree on something, can we just approve it and call it a day? I don't know if anybody else does that, but I see it in my own association. Under this Nonprofit Corporation Act, under the statute, there has to be, it allows for decisions through that unanimous consent to allow the decisions to be made that way. So it's not the greatest means, but it's certainly something, it's an option if you can get everybody on the same page. If, for example, you didn't get enough people, let's say in my example where I said, 3 out of 5 approve something, a tree needs to be cut down in a common area, it's leaning over and it might fall on a house, we need to take quick action to make a decision. All right, I've got 3 board members, we all in agreement, we need to get this done immediately, we all vote in favor of it. Let's say then we realize later on, oh, that probably wasn't the appropriate course of action. One of the things that you might want to do is at the next board meeting that you have, ratify those past decisions and ratify that action as quickly as possible to prevent any additional issues. It's not the appropriate way to do it, but it's a precautionary measure that may assist you in if somebody comes later on and says you made a decision without authority. All right, so let's say you just don't even want to have board meetings right now. Life is tough. The kids are driving you crazy. You're living at home. And the last thing that you want to deal with is a board meeting. There are options just to delay the board meetings. Don't do it by electronic means. Don't do it telephone call or conference call or video chat. Just delay if you can. That will only go so far. In my own association, we did delay one board meeting and said, you know what, given the circumstances, we're going to reconvene about 3 weeks from now, and we're going to schedule the meeting then. So another option here is delay the board meetings until such time as you need to make really key decisions. If you just have board meetings every single month at a specific time, and there's not a lot going on, it is possible to move back those meetings. All right, let's move to now annual meetings. And I like this slide and this cartoon where the large turnout at the open meeting had the board a little nervous, and there's 3 people in the seats. Typically what we run into in annual meetings is not a whole lot of people show up. That apathy, people have busy lives, things of that nature. We are seeing that, we see that quite often. That being said, annual meetings by Zoom or other electronic means, you might get more people interested in what's going on in the community, what decisions are being made, and then also they just might have general questions about assessments, about the pool opening, the playground opening, when can I do this, when can I do that, is the board taking care of this issue, people are unemployment rate's really high, and this house hasn't mowed their grass in 2 weeks because they moved out because they're getting foreclosed on. Is the board taking care of that? So you might have a situation where you're having people more interested now than ever to participate in those meetings. All right, so can you delay an annual meeting? So one of the questions that we routinely get is, in the last couple months, hey, we're supposed to have a meeting in May or April, now June. Can we delay that annual meeting? We've had it every year since our inception in June. That's just the way we've typically handled it. Can we extend it out beyond June? And under the statute, this is the Nonprofit Corporation Act, you can extend out the time to have the annual meeting. And the language is, if the annual meeting is not held on the date designated for the meeting, the board shall cause the meeting to be held as soon after that date as is convenient. So it's a pretty loose standard. What's convenient given a state of emergency? What is convenient during a pandemic? How much time do you really need? Well, let's just say that it was June. Can you now extend it out to September? Give it that 3 additional months? Yes, under the statute, it does allow you to move it out in convenient time. But here's why I said 90 days. So this is an excerpt of that last slide, and it says there's a procedure. If the annual meeting is not held for 90 days designated for the meeting, or if no date is designated for 15 months after the last annual meeting, then what can happen is a co-owner can come in and sue and go to circuit court and ask the court to compel an annual meeting take place. So you can't delay the annual meeting indefinitely. However, so you've got this additional 90 days under this statute, under this language, that you can hold a meeting. The benefit too, though, is if somebody really wants to force the issue and have an annual meeting, they're going to need to file a lawsuit. That's going to take time. They're going to serve that lawsuit. They're going to go in front of the court. They're going to have to ask the court to get the relief sought, and they're going to have to compel that meeting to take place. So realistically speaking, can you delay it perhaps more than the 90 days, just on a practical level, not a legal level, but a practical level? More than likely, yes, given the language in the statute. All right, so how do you participate in annual meetings where you've got a larger group of individuals? So the reason I went through the list of the numbers of the different apps and the different options here is because each one has a different category. We represent some associations who have less than 10 units, and we've got some associations who have close to 1,500 units. So realistically speaking, what works for one association may not work for another association. So if you're going to do these online ways of doing an annual meeting, you're certainly going to want to look at the technology and what's available. I know, for example, Microsoft Teams, it's capped right now at 250, but Microsoft's diligently working on extending it to 1,000 people. And so realistically, I don't know how many associations in Michigan that might apply to, but if that's something that everybody wanted to use and utilize, it's something you might want to check out. All right, so can you participate in an annual meeting by remote means, by a telephone call or a video chat? The answer is yes, unless your governing documents restrict you and prohibit you from doing so. So again, realistically, you have to look at your governing documents and see what they say before you can make that determination. Everybody who wants to participate is allowed to, and there is an obligation on behalf of the association to advise the participants of the means of the remote communication. So if you're going to have a Zoom call, you have to provide the access information, how to log in, that type of thing, to your residents. So if someone's not physically present, what's required to verify or check that the person who's logging in, if you're on, let's say, a video call like this or a telephone call, how do you check? Well, you have to verify that each person is considered present and that they're permitted to vote. So it's a requirement. You have to give reasonable measures for them to participate in the meeting. So like I said earlier, where everybody's on mute right now, you've got to give them the opportunity to open it up to the floor so that they can participate in the meeting if they so desire. And then finally, you have to record the vote or other action, and then that vote or other action has to be maintained by the corporation. What do I mean by that? Well, if you're going to have a vote, you may want to do a roll call vote. And it might take time and it might be lengthy, but go in each individual unit, see if an individual is going to vote one way or another. And you could record the entire, if it's a video call or a conference call, you can record the entire thing so you've got it at a later date. The other option is, just as in here, where everybody can text or chat with each other, you could do a vote via the chat and then maintain a copy of that chat as the record of the vote. So that would be another option in order, instead of a roll call vote, to just have the voting available, have everybody be able to have a period of time where everybody can vote and make decisions, and that's how you would go about it. But you have to maintain that record as part of the association's records. Alternatively, let's say you don't want to go the video route or the telephone conference route. Some of our older associations may not be super keen on using new technology. You know, my grandmother, I spoke to her the other day, and she said, "Joe, I don't know what Zoom is." And so you might have a situation where they may be uncomfortable or don't want to use that type of means to hold a meeting or make decisions. So for your specific community, you might want to think about other ways of effectuating a vote for your community. So one of the ways is under the Nonprofit Corporation Act yet again, and it allows that if you have in your documents, so this is the alternative from earlier where it used to be unless your documents prohibit something, this actually physically requires you to have in your documents the ability to utilize a ballot. And the way that this operates is you send out a ballot to everybody in your community. And it has to, A, set forth the proposed action. You have to be able to vote for or against each proposed action, and you have to give between 20 and 90 days to return the proposed action. The benefit of this statute is it also allows you to vote for directors. So if you're in an annual meeting and you wanted to vote for directors, you could do it by ballot. The problem is that most governing documents do not allow you to vote for directors by ballot. If you're going to have this provision, we've seen in multiple documents that we've reviewed, the exclusion that all decisions can be made by taking an action without meeting, except for the voting of directors. So you're really going to want to look at your specific language in your documents if you have a taking an action without meeting provision. Another option, as opposed to a ballot. By the way, a ballot is mailed out to everybody, and everybody mails it back. So there's no in-person meeting or communication or things of that nature. It's all mailed back, usually to a property manager or a secretary of an association, and then that secretary or property manager tabulates everything for the association. You could have this other option, though, which is a polling place. And this is, again, under the Nonprofit Corporation Act. And again, you have to have this in your documents in order to effectuate a polling place. But the way that it works is the corporation mails out ballots to everybody, and then everybody brings in the ballots to a certain polling location or a certain location on a specific day or days, however you want to set it up. And then at the polling location, all of these are collected. Now, I've never seen this actually utilized in Michigan. Is it possible? Yes. Is it realistic for most associations? Probably not. If you're going to do a mail-out ballot, most people just say, I want to just do the mail-in ballot back. I don't want to deal with setting up a polling place. This was an option.
Hey, Joe, we had a question that sort of ties in, I think, nicely to the polling place about whether associations can use online platforms or they could, set the polling place to be online and vote that way, because there's a lot of different websites out there and companies that are starting to, develop platforms and specialize in online voting for associations.
My initial inclination is to say yes, if you want to utilize that. I've never actually seen that happen or somebody request that. I don't see any problem with utilizing that method, so long as the notice that goes out to everybody communicates that this is how the polling location is going to be operated, and there's going to be a third party that manages it. I personally don't see any issue with it. I don't know if anybody else on the call has any input besides that, but that would be my initial take.
Yeah, there's nothing in the Nonprofit Act that restricts you from having a physical in-person polling location. So I certainly think that you could do it online. It's historically not something that most associations have ever done, but in part because it's nothing they've been ever forced to do or had a reason to do it. And so I think one of the things that we're going to see the results from this pandemic is that associations, not necessarily by choice, but by force, are going to be, required to adopt and to do new and different things that they haven't done before. So, certainly with respect to that or holding online meetings and that kind of thing, if you're going to do that, I'd certainly recommend doing a trial run first, and practicing it before you do the real thing, kind of like we did with this webinar earlier this afternoon. But you need to make sure that you get that right, because technology can have a lot of different glitches when you're doing it for the first time.
And then just to quickly wrap up on the polling place, again, just like the ballot, you have to have the ability to vote for or against the item as it's sent out to you or the notice is. And that's going to be it from meetings, unless there's further questions.
All right, I'll go ahead and open everybody's microphones up if we want to take, let's see. Everybody you're all unmuted. If anybody wants to ask any questions via the chat, or if you just want to ask us a question now, that concludes at least the webinar for right now, and we'll get through your questions. We had a question about, are the written materials available on your website? So that the recording of this, we're not going to put it on the front end of the website. If you're on the premium service plan, all this stuff goes on the back end of the website, and you're able to log in and get that as part of that package. All right, we'll give it another minute, and if there's no other questions, I'd like to thank everybody for joining us tonight. Certainly, I wish you well in trying to figure out all these difficult issues that arise. Certainly keep an eye out on orders from the local health department as well as the state health department. As with anything related to COVID-19, things tend to change pretty quickly. And certainly with respect to the orders that we talked about today in the current executive order, it's certainly possible in the next few weeks that will change, and the restrictions will be further lifted as far as gathering, social distancing, things of that nature. So certainly keep your eye on that. We're going to be here as a resource. We've been writing a lot of articles and putting those on our blog, mycondolaw.com, if you want to go there and check that out. And I just wish everybody well in making those decisions. So thank you very much for joining us today, and we'll let you all get back to this nice June evening here.
All right, have a good night, everybody.
Hey, Kevin and Matt.
Yes.
Jonathan Dean here from Mathai Farm. I just want to congratulate all of you on a tremendous job. I saw you last month, Kevin, with the way you conducted things, and this month as well. And here we are in a more clear situation. I've been working inside the executive team of a major national healthcare company. I was aware of COVID-19 in December because we have an epidemiologist involved. You guys are doing a masterful job of presenting things in the context of a condominium association, okay? So Matt, you and I got to know each other on the phone back in late March. And Kevin, you've been to Mathai Farm, and you're certainly appreciative of what you're doing. And
I appreciate that, John. Is Matt, is he as handsome in person now that you've seen him as he was on the phone?
No, he's wearing his glasses tonight, and I don't even know if my camera's on tonight, and I have a beard that just isn't even shaven well. And Joe, I can't wait to meet you. And Kaylee, you're awesome as well, okay? So
Thank you.
Bring
well, what Kaylee might and Joe don't know is that I was 20 years. I've been in the business world for 40 some years, okay? And I was your partner, board member at the National CPA firm, and I was on the board and active in the, and I formed its consulting arm nationally, okay? So I've been running, and I've overseen attorneys for some number of years, and my dad was a trial lawyer for 50 years, okay? So you are awesome in your field, and we're so glad we picked Herzl, okay? I just want to tell you.
I appreciate that. Thanks. I appreciate the kind words, Jonathan.
Yeah. So, and I'll tell you, a couple of other people were on the session tonight, Bernie Donkerbrook, Kevin, who you know, and so were a couple of others. So I'm going to be in touch with you guys over the next days because we've got an issue separate. We have a governance issue. Okay, so I'm going to be in touch, and I'm going to need your assistance. Okay, and thank you very much for everything you're doing. So
Thanks,
you guys
Jonathan.
have a good night. Okay, see ya. Bye bye.
Bye. All right, well, thanks, everybody. I'm going to go ahead and stop the recording now. So have a good evening.